stop listening to the noise and pull the paper. I pulled the actual titles. I looked at the court judgments, and what the documents show is really a bigger picture than the one that's currently trending, because the real failure here belongs to 50 years of politics.
Guys, want to check out this video?
And it is written down in the judge's own words. So to understand Cooper's Pen, you have to go back to 1970. Residents said that for decades, Prime Minister Manley told them they could have the land. No document, no deed, just his word. And on the strength of that word, the family settled, poured concrete, raised children, buried their dead, but the land was never the government's to give. It is part of the old Orange Grove estate. And here's your first fact for the record. This is not one property. It's two registered titles, both owned by one private company called New Falmouth Resorts Limited. A parcel of roughly 284 acres, which the company has held since 1970. And there's a larger parcel, roughly 705 acres, where Cooper's Pen sits, which the company only acquired in 2006. So from the Administrator General is where they acquired it, and out of that estate of the original owner who had died back in 1980. So when you're keeping that distinction in mind, because the errors in the public conversation comes from mixing up those two titles, right? In 2007, New Falmouth Resort sued 99 residents for possession. The case ran for years, and in April 2010, Justice Donald McIntosh ruled for the company. The residents had to go, and each of the 99 owed $50,000 in damages, and their claim that long occupation had ripened into legal rights, what lawyers called adverse possession, was tested at a full trial, and it failed. But read what the judge actually wrote, because this is a sentence history should remember. The court said the defendants, quote, seemed to be misled by politicians into squatting on private property, end quote, and called them, in the court's own words, gullible defendants, and the court empathized with them. But the court could not grant them the justice because the land did not belong to them. So the court ruled against them because sympathy really doesn't transfer title, and the tragedy really started off from there. The promise was real to all of you, but for you to build a life on a worthless say-so is why you all reached in court, right? In early 2012, a new administration had decided to intervene in the PNP when they took office. 7 weeks in, the Minister of Housing declared both titles an improvement area under the Housing Act, the legal doorway that they can use to compulsorily acquire land that don't belong to them. And presumably, they would have then let the residents stay. The minister filed to freeze the company's court victory, and on the 1st of May 2012, he lodged a caveat on the title, which is a formal claim of interest. The courts did not just reject it, they condemned it, and they had all right to do that. Justice McIntosh called the application, quote, iniquitous, and an attempt to pervert the course of justice and an abuse of the process of the court. When the minister filed a fresh claim, Justice Campbell struck it out in February 2014 and found the stated public purpose was not genuine. It was an attempt to rescue one specific group of people who had already lost, and dressed it up as a housing policy. The point is that he did it after the declaration was made, and the Court of Appeal in April 2016 upheld every word of it. The government paid costs on the punitive scale. Now, here's what our title search had found, and nobody else, I find, has reported this. The government's caveat lodged the 1st of May 2012. On the copy of the title that was pulled, there is no record it was ever withdrawn. So that caveat is still on the people them title, even though the court had ruled against them and upheld it at the Court of Appeal. The courts demolished the legal basis a decade before, and yet on paper the government of Jamaica still holds a formal claimed interest in the land today. The same government now saying this demolition is a private matter with nothing to do with them. So what I'm going to therefore ask the Minister of Housing is whether caveat 1759455 is still on the title, and if so, on what basis? And I would love to know the answer as well as the rest of Jamaica. So to the allegations that's flying around online, the opposition figures or companies connected to them secretly owning this land, I pulled both the certificate of titles and every transfer, every mortgage going back to 1960s. And here's what the chain shows. One corporate owner since 1970 on the smaller parcel, and since 2006 on the larger one, New Falmouth Resorts Limited. The Court of Appeal itself records that Mr. James Chisholm is the company's sole shareholder, chairman, and CEO. The financing history runs through a Bahamian lender in the 60s, a commercial bank in the 70s, and a Chisholm family company from 1976. There's no trace, none, of any current politician of either party anywhere on either title where public figures deny an interest in this land. The register backs them. So I'm reporting that plainly because the standard here is to document, and is the document, not to document. And it is not the direction that the crowd is actually leaning. So when I can give Mark Golding a rest. The register did give us something that nobody explained to you though, because in November 2020, there's a woman named Kathleen Robinson through an attorney that lodged a caveat claiming an equitable interest in 88 acres of the very parcel where the home was demolished. And as of 6 days after the demolition, that caveat shows no withdrawal. So, and that means that with when the bulldozers came, there was an active unresolved legal claim by a third party sitting on part of that land. Who is that person? And what is that person's claim? And does it touch the ground where those 20 homes stood? I don't know how much of that I can find out. So here's the question. Not who owns the land, but whether the demolition that took place was lawful. The eviction judgment is from 2010. The bulldozers came in 2026, 16 years later. Under Jamaica's civil procedure rules, if 6 or more years pass after a judgment is given, you cannot simply enforce it. You must go back to court and get express permission. And one of the judges had said that. So my question is, where is that permission? The opposition spokesman on land is publicly demanding the enforcement order be produced. As of today, no one has produced it. If fresh leave was granted, it should take one letter to prove. If it was not, then this demolition, whatever the merits of the 2010 judgment, was carried out without lawful authority, and everyone who authorized it faces exposure to damages. Lawyer, go get them. The 22 detained men have already instructed their attorney their lawsuit for false imprisonment, breach of constitutional rights may be what finally forces that order into light. And there's an international standard here too. Jamaica signed the UN Convention on Economic and Social Rights in 1975. The UN's guidance on forced eviction says they require adequate notice and must not take place at night. This one began at 3 in the morning. Residents say no notice came. Even where an eviction is legal, the manner of it can still